Thank you.
I just want to mess up your score sheet. But you still have the score. Get on that one. Additional. So you only have count 1 and count 4. I'm going to type it up. Let your mind spin. I thought you was putting on that. I'll take that. I thought, didn't you tell me they brought it back here to see if we could try to resolve it? That's what I thought when you were back here. That's what they do. Drug court, right?
No. It's Marshall.
Marshall. You think about it. I'm just going to keep typing this. You know, come on. I want to let you know what I know. New charge.
All right, Mr. Sutherland.
Good morning, Judge.
No. That's
Good morning,
Judge
sir.
Ward.
I have two cases on the docket today. The first case that I would like to call is Mr. Eddie Register. This is case number 25 CF 1444. We have depositions set next month, which is April 24th, in this matter. I've received a modified offer from the state, which I need to relay to my client. I anticipate depositions will need to be completed in this matter. I would ask for a court date on the other side of the April 24th date.
Stay.
The April 24th date?
Yeah, for depositions.
Yeah, that's fine.
He said that's fine.
No objection.
All right, so 5/11.
Thank you, Judge.
Thank you.
The next case I have is Mr. Theodore Mel. This is case number 25 CF 450. Mr. Mel is present and approaching. And we have a negotiated resolution with the state that Mr. Mel is interested in entering into today. There is no objection from the state to postponing imposition of this sentence for a period of time in order for Mr. Mel to get his affairs in order. He has a family in Kentucky. He needs to get his brother to move in with his family in Kentucky to be able to take care of them while he is incarcerated. And he also needs to try to make a little bit more money to support his family while he's going to be absent. I would ask that the court consider withholding imposition of the sentence for a period of, Mr. Mel requested 2 months, but any time you give him would be appreciated. May I approach?
Granted.
And once again, the score sheet need to be completed. The last page, we have to.
Well, does the state agree to the deferred sentencing?
Yes, Your Honor, but the
Okay,
state
well,
needs
then we'll tender the score sheet when we actually sentence.
at that time.
Yes.
All right, announce the terms and conditions, please.
The terms and condition of the plea agreement, Your Honor, is going to be 21 months DOC followed by 8 years of sex offender probation with all the statutory requirements, no contact with minors except for Mr. Mel's biological children, and then a sex offender designation. And there would be no pros to counts 3 and 4 in exchange for adjudications of guilt on counts 1 and 2.
And that's the state's agreement.
It is, Your Honor.
All right, raise your right hand, please. Do you swear, excuse me, do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I do.
All right, and you can put your hand down. You heard what Mr. Sutherland said on your behalf, and you signed the written plea form.
Yes.
How old are you?
I am 51.
And how much school do you have?
I have a bachelor's degree.
You able to read and understand the plea form?
Yes.
Did you do that before you signed it?
Yes.
And is what you read in the plea form what Mr. Sutherland announced?
Yes.
Now, do you understand by this plea arrangement that you're pleading no contest to the announced charges?
Yes.
And that tells me you believe the state has the evidence necessary to convince a jury of your guilt beyond a reasonable doubt, and you're not going to contest that.
Yes.
Do you understand by making this plea, you're waiving your right to a trial by jury where the state would have to present that evidence and convince the jury beyond a reasonable doubt of your guilt?
Yes.
Now, you've got two things going on here. You've got an agreed-upon sentence, but you're also asking for your sentence to be deferred.
Yes.
Because of that, there's a dynamic here that I need to explain to you carefully. If you appear for sentencing as directed by the court, you have no additional charges, then the court would impose the agreed-upon sentence, which is the 21 months at Department of Corrections, followed by 8 years of sex offender probation with all the statutory requirements, including the no contact and the sex offender designation. If, however, you fail to appear as agreed, or if you get new charges, then this plea agreement constitutes an open plea to the court, which means that the court would then be allowed to sentence you to any sentence up to and including 2 5-year sentences in state prison consecutive for a total of 10 years. Do you understand?
Yes.
Has your lawyer talked to you about that, or do you have any questions about the dynamic of an agreed-upon sentence if you appear and an open plea if you don't?
Yes.
Has he answered all those questions?
Yes.
Okay. All right. And with that, have all your questions about the plea and its impact on you been answered by Mr. Sutherland?
Yes.
And are you satisfied with how Mr. Sutherland has represented you?
Yes.
All right, the court will find the plea to be freely and voluntarily entered into, and will accept the plea, and we'll set this for sentencing. What's our first date in May?
It would be May 14th.
May 14th,
Thank you so
Thank
much,
you,
Your
Your
Honor.
Honor.
Is that May 14th?
9 o'clock.
That's all the cases I have today. May we be excused?
Yes, sir, Mr. Sutherland, thank you. Ms. Switek.
Morning, Your Honor.
Good morning, Ms. Switek.
Your Honor, I'm here on an emergency motion in case 2018 CF 1690, Timothy Anderson. It's for a protective order. This matter is set for judge trial on March 26th and 27th. We came to an understanding that we would submit in writing a statement of facts, which we did approximately a month ago. As far as I know, that has not yet been filed by the state. They have the original copy. And a couple of emails back and forth late last week. Mr. Little proposes to submit jury instructions to the court. I don't know why, being this is a judge trial. But we're asking that if those instructions are submitted, that we also submit the full plethora of insanity defense instructions absent voluntary intoxication, which is 3.6D. that the other ones ride along with that. Mr. Little objects to that. So that's issue number one. Issue number two is that,
Well, there were two issues there, right? One was the agreement of fact, and the other one was the jury instructions.
right,
So there's two,
one,
all right?
other than the agreement of fact not being filed yet.
I believe Mr. Little tendered that late Thursday afternoon to the
Okay.
court for review.
All right,
And then I saw your motion, so I didn't review it,
okay. But,
because I wasn't sure the dynamic involved,
well, that's the dynamic as far as the jury instructions are concerned.
all right?
The other dynamic that's present is that the state, now that that has been signed off on by myself and my client and submitted to the court, proposes to call fact witnesses. My understanding was that we're doing it in writing and you submit to the court the issue of insanity only, and that would entail expert witnesses only. But Mr. Little now wants to have fact witnesses address the court, and we oppose that.
All right. Mr. Little?
The first thing was jury instructions, Judge. I mean, I come from Escambia County, granted, but it was practiced in Escambia County to provide the judge with the applicable law for the case as to the jury instructions. Defense counsel mentions the insanity instructions. My issue with the insanity instructions goes with the facts that the state submitted to the court that was signed off by both parties. And my understanding was that we were stipulating to the underlying facts regarding the first-degree premeditated murder only, and the issue before the court was insanity. The defense counsel proposed involuntary intoxication, and that instruction specifically addresses premeditation and whether the defendant, as a result of involuntary intoxication, had the premeditated intent to murder. That goes against what the state defense has agreed to in the facts that were presented to the court. The third thing with fact witnesses, Judge, defense counsel represented the court that we were going to have expert witnesses only. Defense counsel sent the state a witness list that included not just experts, but the defendant's mother as well as his brother, and also the defendant's prior counsel on the case. Judge, the state and defense stipulated the underlying facts regarding the homicide. We didn't stipulate to the underlying facts regarding insanity. And as far as the state is aware, if the defense counsel is going to bring up the defense of insanity, the state should be allowed to rebut that insanity defense with witnesses who can testify to the defendant's behavior at the time, which was not included in the stipulation of facts that was provided to the court. The state's entitled to present its case, Judge.
Mr. Little's correct that we do have additional witnesses, but they are only being called as to the issue of insanity and his law.
Is that what you said, Mr. Little, that your witnesses are only as to the issue of insanity, not to underlying homicide?
It's to the issue of insanity, but those facts are kind of merged together in this circumstance.
Okay, I just want to be clear.
Yes, sir.
Go ahead, Ms. Switek.
But our lay witnesses are being called to verify that Mr. Anderson's long history of insanity is evidenced by Baker Acts and medication and so forth, and that's why they're being called. But if Mr. Little is limiting his witnesses to address the issue of insanity, then I really have no objection.
All right.
Then we're left with the jury instructions. The involuntary intoxication defense is also a defense because it says involuntary intoxication leading to insanity. So that's why we want that one.
I keep them up on my computer all the time whenever I'm working on a criminal case, because we all know that's where we go to see what the elements of the case are. So I don't really understand what the debate is from either side. If you want me to look at certain jury instructions that apply to the case, then tell me what they are. I don't think you need to send me paper
And that's my
copies.
feeling on it as well.
Yeah, absolutely. And then if, we'll hear the evidence and see which ones actually apply, and I'm sure as competent lawyers, you'll be arguing the appropriate legal standard for me.
Nothing else,
Do
Judge.
do we need an order coming out of this, or is the record sufficient?
I think the record would be sufficient.
Mr. Little's state agree.
The state agrees, Judge.
All right, so I will now review the factual, and I believe there was a CD that was provided as well. Are you aware of that?
Yes, but I haven't been provided that CD.
You haven't been provided the CD.
No.
What's on the CD?
It's referenced in the stipulation of facts. It's the actual dash cam from the victim's in-car camera.
Okay, so that is copies of evidence that has previously been presented to the defense, but not in the format you gave to the court.
Correct.
Okay, so you probably need to give it to the defense in that format so that they'll have the opportunity to see it, since you're asking me to review it in advance of the trial.
Yes, sir.
Okay, when can you get that done?
Should I, Judge?
Okay, all right, very good. Anything else?
No, Your Honor.
Okay, all right, thank you very much. Anything else from you, Mr. Switek?
No, Your Honor.
All right, Ms. Merrifield?
Morning, Your Honor.
Good morning.
Judge, the first case I have, Brittany Merrifield on behalf of James Lawrence. It's 25 CF 1630, 2146, and 2147. We set this case for docket day. Mr. Lawrence was evaluated based on some concerns I had by Dr. McDonald for competency. We did file the confidential forensic evaluation on the 11th. I have an extra copy if the court hasn't had the opportunity to review that filing.
Hold on just a second. When I looked, it wasn't in the record. It's twice. That's the cornerstone with
Yes,
the
sir.
exam date 2/26/26.
Yes, sir, that is the report from Dr. McDonald.
The state had the benefit of the report.
Yeah, Your Honor.
All right, give us a quarter second. Thank you.
Thank you, Judge. And based on Dr. McDonald's opinion that he is not competent to proceed, he does already receive services. We got him established through APD. Her recommendation is that he receive competency restoration services. And as the letter suggests, she believes 6 to 12 months he may be able to restore competency. So I would ask that he be allowed to receive those services through APD and perhaps set the case off 6 months unless we receive something from APD sooner than that that indicates he has a restoration.
There would have no objection.
I guess, if you'd approach, please. All right.
And does Madam Clerk have a court date, or we'll just receive it through the portal at a later time?
Yes, we'll set this for just a status review in 6 months, Madam Clerk.
Do you want the first September miscellaneous date?
That sounds good. And that'd be status only, and if we have a written status report, then we'll waive his appearance and then the matter can be continued after the state's review.
Thank you, Judge.
That would be September 17th at 9 a.m.
9/17 at 9 a.m., Madam Clerk?
Yes, ma'am.
Thank you.
Yeah.
Thank you, Judge. The next case I have is Brady Merrifield on behalf of Scott Polachek. It's 25 CF 1438. Judge, I do have a written plea in absentia, if I may approach.
Granted. All right.
And in 25 CF 1438, Mr. Polachek is withdrawing his previously entered not guilty. He is entering a no contest plea to the lesser misdemeanor. The Florida statute is referenced.
All right, so this credit for time served, no, it's a, yes. Fees and costs only, right?
Yes, sir, it's just fees and costs.
To the misdemeanor.
Correct.
And that's the state's agreement?
It is, Your Honor.
All right. 90 days to pay. There you go.
The last case I have, Judge, is Curtis Tatum, 25 CF 1040. There is a waiver on file for Mr. Tatum, and as the court may recall, we did have a conversation about this. There is another matter that we are trying to get resolved within this case, and we're still waiting on an update from that county. I discussed this with Mr. Snell, and we believe if we could set this on a miscellaneous, it may give enough time so that we can get all those wires crossed and talking.
That's correct, Your Honor.
We don't want to lose track of it, though, Judge. We do have a resolution in our case.
All right, so we want to go to the first day in April, you think? That's 4/16, is
Yes,
that
sir.
right, Madam Clerk?
Yes, Your Honor.
All right, 4/16 for status.
Thank you, Judge. And that should be all I have.
Madam Clerk?
That's correct.
Thank you,
Okay.
Judge.
Thank you. Mr. Yosti. Good morning, sir.
I just have Walter Franklin Robinson, who's present before the court in 2025 CF 1550. Mr. Snell and I are trying to reach a resolution to this case. I'm going to ask that the case be continued one cycle to reach a resolution. I had issues maintaining contact with Mr. Robinson, but I now have solid contact with him. And I think we can, we're considering a program for, as a resolution for the case to avoid having to take the case to trial, so.
I believe that's correct, and I don't,
Even though if we do set it for 5/11, I think there's a good possibility we can bring it in way before then.
All right, it'll be continued to 5/11. If you reach an agreement, then come on in, we'll take the plea anytime I'm here.
Thank you.
All right.
That's all I have, Your Honor.
Thank you now. Good day.
Thank you, Your Honor.
Mr. Flowers.
Your Honor, good morning. Approaching is Matthew Christopher Reeves. Case number is 24 CF 802. Your Honor, I'm going to refer to the plea agreement. Mr. Reeves was set today for plea or trial. At this time, he would withdraw his previously entered plea. Enter a plea of no contest consistent with the information. It's a second-degree felony. The sentence that's been agreed upon is as follows: that he would be adjudicated to be guilty, placed in the State of Florida Department of Corrections for a period of 10 years with credit for time served. Statutory fines and costs, which I understand and the clerk advised were $515, and that is the agreement of the parties. In addition, Your Honor, I've been provided a criminal code score sheet to which there is no objection. May I approach?
Granted. That's the state's agreement. It is, Your Honor. All right. All right, Mr. Reeves, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you can put your hand down. You heard what Mr. Flowers said, and you signed the written plea form.
Yes, sir.
How old are you?
29.
And how much education do you have?
A double associate's degree.
You able to understand and read the plea agreement?
Yes, sir.
And did you do that before you signed it?
Yes, sir.
And is what you read what Mr. Flowers just told me?
Yes, sir.
Do you understand by this plea arrangement that you're pleading no contest to the announced charge?
Yes, sir.
And by doing that, you are telling me that you believe the state has the evidence necessary to convict you of this charge, and you're not going to contest that.
Yeah.
Do you understand by doing this, you're waiving your right to a trial by jury, or Mr. Flowers would help you make the state prove that your guilt to that jury?
Yes, sir.
And the sentence in this case would be an adjudication of guilt, the statutory fines and costs, and a 10-year Department of Corrections sentence credit for all time served. Is that your agreement?
Yes.
All right. Mr. Flowers answered all your questions about the plea and how it affects you?
Yeah.
And are you satisfied with how he's represented you in this case?
Yeah.
All right. The court will find the plea to be freely and voluntarily entered into and will accept the plea.
Your Honor, I have two more matters that I was uncertain whether they remained on the docket or not, but the clerk can help me.
As we all are
Yes,
lately.
sir. The first is Frederick Vaughn.
And what's that case number, Mr. Flowers?
It is 25 CF 489.
I have it on for POC today.
Yes, sir. Judge, and here's the situation. The state would agree. I was sent over a pretrial intervention agreement Friday. Judge, we're asking, given that circumstance, it's no one's fault, if you could just pass the matter so we could sign off on the PTI
All right.
agreement and sign it.
511 for PTI status, Madam Clerk.
Thank you. Judge, the other matter, 25 CF 1863, we're in the same posture.
That's correct, Your Honor.
That's McCullough, right?
It is, Your Honor. And it's exactly the same as the Vaughn matter, with this exception. Ms. McCullough has been in Jacksonville with Mayo Clinic, but we believe everything can be executed by 5/11. If the court would put us on for that date, please.
All right. 511 for PTI status.
No, I believe that's all I have.
Madam Clerk, that's all for Mr. Flowers?
That's all for Mr. Flowers.
Okay, thank you very much.
Thank you, Judge.
Mr. Shaw.
Good morning, Judge.
Good morning, Mr. Shaw.
First case I have on the docket is Geraldine Swanson. That's 24 CF 2748. met with the state again last week. We believe we have it worked out. Just got to get a few details so we can put it on a miscellaneous date or the next pretrial, whatever the court's preference is.
This is the Swanson matter?
Swanson. Yeah.
Our next miscellaneous date be 4/16, so you want to set it then for change of plea?
4/16, Judge, yes.
Okay. State?
That would be good for the state.
All right, change of plea on 4/16.
Next case, Judge, I have is Jimmy Velasquez Bermudez. We had an interpreter here earlier, Judge, but all we're going to do.
Case number?
That is 25 CF 147.
All right.
We're asking, the state's alleged victim is out of the country. I'm not sure if the alleged victim is coming back to the country. So I think it's going to resolve itself here shortly.
So I'm going to try to work this case out. I believe that it would be appropriate to set it for 5/11, and hopefully we'll have it resolved before then.
All right, 5/11 for status only.
Thank you, Judge. And lastly, Judge, I was asked by Mr. Jake Patel to cover his case. He's in front of Judge Wells over in Walton County this morning.
Yes, sir.
He has Sharon Potter, P-O-T-T-E-R. I do not have the case number.
Looks like 1861, Madam Clerk.
That's correct, Your Honor.
All right.
He's asked to continue that one cycle. He anticipates it'll be a PTI.
That's correct, Your Honor. We would have had that done, but Ms. Potter was out of state, or is still currently out of state taking care of her mother. And so we are getting the PTI, and it should be off the docket before the next date.
All right, 5/11 for PTI status.
Thank you, Judge. I believe that's all I have.
All right, thank you very much. Good day, Ms. Shaw.
Thank you, Judge.
Ms. Dudley. Good morning, Ms. Dudley.
I think the first one I have is Keon Purnell.
Purnell. And I think that's 24 CF 2414 and 24 CF 164.
Yes, sir. Yeah, he was left PRC with us for continuance of the next pretrial.
All right, State.
Judge, we have extended an offer. I think Ms. Dudley needs to speak to her client about it. It's my understanding that she also wanted to review some of the cellular phone downloads. Based on that, we don't have an objection, but we would request that this be the last continuance, and if we need to try it, we could get that on for next cycle before the court.
All right. Ms. Dudley, you think that's practical considering the age of the case? I know there were some issues.
Yes, sir.
With
I just
you
think
coming on board and also the digital evidence, but you think that
I
that's...
have it. I have downloaded it. I just need to go through it so I can talk to my client about some of the cell phone stuff, so we can make a decision if we want to take the offer or go forward with trial.
You think we can try it next cycle, though?
Yes, sir.
Okay, all right, good. All right, very good. We'll continue it to 5/11 with the concept that either it's going to be a plea or a trial.
Thank you.
Your Honor, the next one I have is Timothy Redinger and 24 CF 1425. Your Honor, if we may approach on that case?
Yes, ma'am.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
And also 511 on Mr. Redinger.
Yes, for status. And once again, if things sort out, you're able to contact my office, then we'll work on going ahead and setting a special date for the SYG.
Yes, sir.
And Judge, that's all I have, maybe, excuse me.
Yes, sir.
Thank you, Judge.
Careful in this weather heading back.
All right, next I have is Darice Terrell. I have 24 CF 1686.
Jason McKenna also from the Search Warrant, case number 25 CF 2269.
Your Honor, Mr. Terrell is going to enter a plea of no contest, and 24 CF 1686 is going to be a lesser included in count 1 to possession with intent to sell 893.131A1 as charged in all the other counts and cases, and to be for 24 months DOC concurrent. If I can approach the
Does that dispose of your case too, Mr. McKinney?
It does, Judge. 25 CF 2269 is included in that plea agreement. And I signed on this plea agreement as well.
All right. Do we have a score sheet?
I will, the one I have doesn't reflect that, so I'm going to have to modify one
Okay.
and
All
provide
right.
it.
But the state and the defense do agree that the sentence imposed is a guideline sentence?
correct, Your Honor.
Yes, sir.
Okay.
Yes, sir.
All right. And Madam Clerk, fees and costs, correct?
It's going to be 615 for case number 24 CF 1686 and 515 for case number 25 CF 2269. $850 public fee for 25 CF 2269.
Madam Clerk, given that the charge is an SMZ, is that the 1167 or is it 615?
Thank you.
All right. Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you could put your hand down. Now, you heard what Ms. Dudley announced, but she announced for both cases where she represents you in one and Mr. McKinney represents you in the other.
Yes, sir.
Okay? And you signed the written plea form.
Yes.
How old are you?
I'm 31 years old.
And how much school do you have?
It's about 11th grade.
All right. You able to read and understand the plea form?
Yes, sir.
And did you do that before you signed it?
Yes, sir.
And what you read in the plea form, is that what Ms. Dudley just announced to me?
Correct.
Do you understand by this plea arrangement that you're pleading no contest to the announced charges?
Yes, sir.
All right. And by pleading no contest, what I understand you to tell me is that you believe the state could prove your guilt on the announced charges, and you're not going to contest that.
Yes, sir.
By doing this, do you understand that you're waiving your right to a trial by jury where the state would have to prove your guilt?
Yes, sir.
In this case, you'll be adjudicated guilty, and you'll be sentenced to 24 months in the Department of Corrections, credit for all time served. And is that concurrent, right?
Yes, sir.
With both cases.
Yes, sir. All cases and all counts, Your Honor.
And only count 1 is a lesser included. The other ones
Or as charged.
are as charged.
I guess we need to do time serving with misdemeanor, Your Honor.
Yeah, time served on count 3, Madam Clerk, of 1686. And there's no minimum on count 2, State?
No, sir.
Okay. And so and that's credit for time served. Now, you've got some fees and costs. Will 2 years after your release be enough time to get those things paid?
Correct, yes, sir.
Now, I don't know your arrest date, but this sentence is concurrent, meaning you serve at the same time, but your arrest date on each case may be different. So your credit for time served may be different. So your sentence on the 2 cases may not end at the same time. Does that make sense? Yes, absolutely. Does that make
Yes, sir.
sense now?
Yes, sir. Yes, sir.
I know, it's kind of nonsensical, but I try to explain that because when you get over there and they give you that and you go like, well, wait a minute, I thought we're serving the same time. I like to explain that in advance so you're not surprised by that and kind of understand where that's coming from.
Yes, sir.
Because it's, as you probably heard, it's another government form and trying to figure it out. We all spend years just figuring the forms out. So with all of that now, have Mr. McKinney and Ms. Dudley answered all your questions about the plea and how it would affect you?
Yes, sir.
And are you satisfied with what they've each done for you in this case?
Yes, I am.
The court will find the plea to be freely and voluntarily entered into and will accept the plea. Thank you.
Thank you.
Your Honor, the last case I have is Jimmy Thomas at 25 CF 1055. This was left PRC. That's for continuance. There is just a couple body cameras that I want the state to see if they have of the initial contact with Mr. Thomas. So I would ask for continuance, see if we can look at that and hopefully get it resolved next cycle.
So you believe there's body cam after the initial encounter?
So we don't have any body camera when they approach the vehicle, either officer. We have a dash cam and we have the body camera of the canine officer that comes up. We don't have the body cam of the initial contact.
Of the initial?
Yes, sir.
Okay. State?
No objection.
All right, it'll be continued to 511. Is state working on looking for that?
Yes, sir. I didn't realize she had it until yesterday, so we were trying to work it out today, and then she realized that, I guess, that she didn't have that and really wanted to watch it first, and I don't disagree with that.
All right. All right, very good. Is that all for
Yes,
Ms. Dudley and Madam Clerk?
Yes, Your Honor.
Thank you.
Okay. Thank you, Mr. Durrell. Good morning.
Your Honor. May it please the court, Dustin Durrell. Your Honor, I have Mr. Brandon Leuen today. Mr. Leuen, President approaching, Your Honor. This is case number 25 CF 1976. We do have a written plea, if I may approach.
Granted.
Thank you, Mr. Honor. Yes, Your Honor. At this point, Mr. Leuen will withdraw his previous entered plea of not guilty, enter a plea of no contest. Charge 1 will be the lesser included offense of reckless operation of a vehicle. The statute number is on the plea, Your Honor. I'm sorry, I don't have it on the top of my head.
316.1911B.
Thank you, Your Honor. That will be 1 year of standard probation supervised by JCS. It is a misdemeanor. Court cost in the amount of $368. Count 2 will be as charged, resisting officer without violence. That will be 6 months standard probation consecutive to count 1 for a total of 18 months probation.
All right, is that the state's agreement?
It is, Your Honor.
All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, Your Honor.
All right, and you can put your hand down. You heard what Mr. Durrell announced, and you signed the written plea form.
Yes, Your Honor.
Do you understand that you're pleading no contest to the announced charges and waiving your right to a trial by jury?
Yes, sir.
In this case, adjudication will be withheld. You're going to be on 18 months of probation total, It's two separate terms, one of a year and one of 6 months.
Yes, sir.
All right? And you'll have the full 18 months to complete all the terms and conditions.
Yes, sir.
Okay. Mr. Terrell, answer all your questions about the plea and how it affects you?
Yes, sir.
And you're satisfied with what he's done for you?
Yes.
I'll find the plea to be freely and voluntarily entered into, and I'll accept the plea. I don't know if there's one of those JCS.
I've already sent it to him.
Okay, very good. There you go.
Just in case.
That way you can
Take it
get,
extra.
you just click on that and get started.
Yes, Your Honor.
Thank you now. Good day.
Thank you very much, Your Honor. That's all I have.
That's all you have? Okay, good. Ms. Jaquith?
She just stepped out, Your Honor. Can I take one case I want on the docket?
Yes, as long as it's okay. You jump in front of other folks.
Y'all mind, it's one case. I appreciate y'all.
Okay. Right, Mr. Rare.
Thank you, Your Honor. For the record, David Rare for Mr. Ansel Sterling, 24 CF 2653. The case is currently set for trial. End of last week, we received a new amended discovery exhibit from the state listing a new law enforcement witness, Casey Campbell. Given what he normally would testify to at trial on the computer issues and what the charges are, we need to depose him and get a transcript. So at this time, I'd ask for a continuance so we can try to schedule his deposition.
State.
Your Honor, the state has shared Mr. Campbell simply because he did the phone download itself. The extent of his testimony is really for a chain of custody purposes. I think that it could be deposed even before we go to trial. I don't believe we need a full continuance for this.
Given the scheduling issues that I know that I'm going to have in my office, I'd ask for a continuance to the next cycle with the expectation if y'all can help us make that work and then make sure we get it transcribed in time. We're not on a short time frame. We'd have us teed up for trial next cycle, and I'll try to make that happen.
Well, please approach.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping
All right,
qualified
so,
heroes save money is my passion.
Reach out and
Wanna
get the
help you?
deposition set ASAP. I know what their schedule is, and you need to advance that so we can assure that this case stays on the trial docket for the next cycle. So you need to, I know you're announcing we're setting depositions on 4/21. Realistically, if you take the depositions at the end of April, the transcript is not going to be available by the time of our next cycle. You see where I'm coming from. So that one needs to take priority if we're going to keep it, because this case is 2.5 years old almost. So
Yes, sir.
it needs to go next cycle. So advance that deposition and make room for us so that we can assure this trial date next cycle, okay?
Yes, Your Honor, for the court and the defendant's information, I wanted to state that this morning I filed an amended information changing the subsections or the statutes in count 1 and 2 from 3A on count 1 to 3B, and from 4A to 4B in count 2. So he would have to be arraigned on that at the next court date, I guess.
All right,
And we can do that when we come back at pretrial.
okay. All right, very good.
All right. And then, Judge, what's the next pretrial date? I think I know what it is.
5/11.
It is 5/11, perfect. And that's all I have on the docket, Your Honor. Thank you.
All right, thank you, Mr. Rare. Ms. Jaquith.
Thank you, Your Honor. The first I have is Orville Madden in 25 CF 2030. Mr. Madden's an inmate.
Yes, ma'am.
Your Honor, in Mr. Madden's case, I was just appointed on Friday, so I haven't even had an opportunity to conflict check, so I will be moving to continue this case.
All right. State.
Oh, and Your Honor, that's my bad. I told Mr. Gomez we didn't have any. I forgot about Mr. Madden. We just withdrew. We're moving to continue, or the PD's office just withdrew, and we're moving to continue because I haven't.
No objection to the state.
All right, matters continue to 5/11.
Okay, if I don't have any conflicts, I'll be out to see you soon, okay? The next I have is Danielle Seberg. Ms. Seberg is present and approaching in 25 CF 2407. Your Honor, I'm going to ask to move this to the May 11th docket. I do anticipate we'll have a resolution, but there's some final matters we need to resolve before we're able to enter a plea. And the state does not have an objection. I spoke with Mr. Snell about this previously.
That's correct.
Hold on just a second.
Yes, sir.
Pick up here. All right, so full cycle continuance.
Yes, please, Your Honor.
All right, continue to 5/11.
Thank you, Your Honor. Your Honor, the next I have is Ryan Walden. Mr. Walden is present and approaching in 25 CF 1951. We've reached an agreement with the state. He's going to be entering a no contest plea as charged. The agreement is a withhold of adjudication, 3 years probation on each count to run concurrently with one another, $40 per month cost of supervision, $615 in court costs, and $150 cost of defense. He'll need to submit to a substance abuse evaluation within 30 days of this plea and begin any recommended treatment within 60 days. He needs to complete 50 hours of community service work. He's to have no controlled substances without a prescription and maintain gainful employment or show proof of 3 job applications per week. Mr. Walden does live in Walton County, Your Honor. I've already made probation aware of that. He is also aware that he needs to go check in Fort Walton Beach before he leaves and goes back home, and that they will transfer him to Walton County. And I have no objection to the score sheet. May I approach?
Granted. Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I do.
Okay, and you put your hand down. You heard what Ms. Jaquith said, and you signed the written plea form?
Yes, sir.
How old are you?
40.
How much school do you have?
High school.
You able to read and understand the plea form?
Yes, sir.
Did you do that before you signed it?
Yes, sir.
And is what you read in that form what Ms. Jaquith just told me?
Yes, sir.
And do you understand by this plea arrangement that you're pleading no contest to the charges?
Yes, sir.
Is that yes?
Yes, sir.
Okay. And by pleading no contest, what I understand you to say is that you believe the state can prove your guilt and you're not going to contest that.
Yes, sir.
And by doing this, do you understand you're also waiving your right to that trial where the state would have to prove your guilt?
Yes, sir.
Adjudication will be withheld. You're going to be on 3 years of probation with the standard conditions plus the evaluation and recommended treatment, the community service hours, and no substances without a prescription. And you must look for a job. You must get a job or be looking for a job as one of the conditions. And if you were to decide to seek training or education that would lead to gainful employment, you can mention that to probation, and I'll support you in that. The goal is to set you up for success, okay? Ms. Jaquette answered all your questions about the plea and how it affects you?
Yes, sir.
You satisfied with what she's done for you?
Yes, sir.
The court will find the plea to be freely and voluntarily entered into and accept the plea.
Thank you, Your Honor. Your Honor, the next I have is Tatiana Weeks in 25 CF 1941. Ms. Weeks is present and approaching. Your Honor, we have reached a PTI agreement with the state. Everyone has signed. If I may approach Madam Clerk to submit that.
Granted.
And Your Honor, we have provided a copy for Ms. Weeks that's also signed for Ms. Weeks to take to probation. She's aware she needs to go to probation today and get signed up, but for right now, I'd ask to continue this to May 11th for a control date, although I have no concerns about it falling off the docket. So basically, we just give you 14 to make sure all the people.
All right. We'll set it on 5/11 for status.
And Your Honor, that is all I have before the court this morning, if I may be excused.
Yes, ma'am. Anything else for Ms. Jaquette, Madam Clerk?
No, Your Honor.
Okay, thank you.
Thank you, Your Honor.
All right, Gil Powell. Good morning, Mr. Powell.
One case, Judge, James Valentine, 25 CF 1347. At pretrial, we agreed either plea or continuance. He has an appointment with Dr. Harper either this week or next week, and we'd move for a continuance at this time.
All right, State.
The one thing I want to put on the record is that the offer of 33 years is not open anymore. The state is revoking that offer.
Okay. All right, and so matters continued to 5/11.
Thanks, Judge, that's all I have.
All right, thank you now.
Okay, thanks.
Dixie Powell.
Morning, Your Honor. Dixie Dan Powell on behalf of Zehan Wayne. And Judge, we...
What's that case number, Mr. Powell?
Okay. Yes, sir, Your Honor. It's, hold on. It's 2026 CF 000144F.
Thank you.
And we're here on a motion for return of property. We were here Thursday, and we were... I met with Mr. Snell, and we postponed it till today so he could talk to the deputy or the police officer that has the green card and the IDs. I don't guess he could get a hold of them. I would just ask if the court could give us an order returning the property. We'll stipulate on the record that that we will not object to any copies being used. It's just paper document. If we could get at least her green card back, because it's a letter from immigration when they renew their green card, and they have the green card and the letters. And really, if the court had an opportunity to read our motion and our email where we laid it all out, because really, I believe the state has really no case here. So this lady was just here. All the IDs are valid. The driver's license are valid. Her immigration green card is, of course, valid. And the way the immigration does is instead of when it expires, they issue a letter extending it because they don't have time to get all the new green cards. So she has that letter. She can't do anything without the letter. She can't.
Mr. Snell?
Sorry. I was talking on a different case.
Oh,
this is the case from...
Yeah. Returning the green card and the IDs.
Right. I thought we resolved this last week. We moved it to 4/16 so that we can try to... No,
I think we moved it till today. 3/16, so we could try to, you could meet with the officer yet Thursday and Friday.
Well, if you'd approach.
Years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire. Take one. Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Fire. Damn thing ain't working. Whoa! Not cool, bro.
I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Do we have someone on Zoom? Did State?
Yes, I believe it's Mr. Rivas.
Okay. Good morning.
Morning, Your Honor.
And which case are you here for today?
We have Mr. Rodriguez Espinoza. This is Jose Rodriguez from the law office of Jose Rivas, Your Honor.
And what is the status of this case?
The depositions were complete on those handling the murder trial, so we need to follow the client with the mitigation. We want to present also, we're getting together, and I'm not sure if we have an offer or not in this case.
You know, if Mr. Rivas doesn't have an offer, I'll make sure that I will send him one before the end of the day.
So we're asking if we can continue this, Your Honor.
There's no objection from the state.
All right, it'll be 5:11.
Thank you.
Is that another docket day, Judge, as it's called there, or?
Yes, sir. That's the pretrial conference is on 5/11, and then the docket day will be what day, Madam Clerk?
Docket day would be May 18th.
May 18th is the docket day. That's our 2 cycles.
Okay. Thank you, Your Honor.
Thank you. Now, good day.
You too, sir. Thank you.
Judge, may I call Heidi Venegas? This is case number 25 CF 2282. We'd set it on today for effectively a PTI status. I do have the PTI signed by all parties. May I approach, Madam Clerk?
Granted.
And I believe the process we're doing now is to set this for a control date, but I do have a second copy for her to take over to the probation office.
All right, PTI status on 5/11. Thank you.
Thank you. Judge, I do have several more in the courtroom that we are working on finalizing some agreements, so I'm going to pass it to Mr. Costa. Mr. Costa.
Then I have Mr. Ryan Moss in the courtroom, case number 25 CF 1562. Your Honor, Mr. Moss, we're waiting for some medical records for the victim on this case. I don't believe the state has received them yet.
Not at this time, Your Honor. Our victim advocate is working with the victim to actually get those records. We just want to make sure that we have and can review the injuries that were allegedly sustained before we finalize the offer and hopefully resolve this case. I anticipate that should happen sometime this week. So if we can bring it in earlier than 5/11, then we will make sure we do that.
All right, set for 5/11. Stay in touch with your lawyer. If they have arrangements, they'll ask you to come back sooner, okay?
Okay.
Thank you.
Your Honor, I have Miss Jordan Lewis. She's not present. It's a PTI status. It's 25 CF 0651. The PTI has been signed. Probation has it. I spoke to probation this morning. They're just trying to have an actual phone conversation with her to instruct her. When I'm out of court this afternoon, I will call her and make sure she gets in contact with probation today.
So status on 5/11?
Yes, Your Honor. It'll likely fall off before that.
All right. State, any objections?
No objection, Your Honor.
All right, so ordered.
I have Mr. Ryan Nano, 25 CF 2049. Your Honor, this is a PTI status. I had advised him that I would send him paperwork not to be here today. I'd asked if we could set this for 5/11 with the understanding it'll probably plea out well before that. I have an offer to discuss, it's not a PTI, but it's a new offer to discuss with him, which will likely plea out sooner than May 11th.
All right, state.
No objection, Your Honor.
So we was on today for PTI status, and we're just continuing it one more for...
Yes, Your Honor, it's, the offer's changed from a PTI to a misdemeanor. I just need to make sure that's not going to affect his work. I don't believe it should, and we should be able to get it set for a plea well before the May 11th date. He would have been here to do it today. Last week I misinformed him.
All right. 5/11 then, if all else fails.
Thank you, Your Honor. The rest of mine are inmates. Do you have anybody? Oh, they do? Okay. Your Honor, this is going to be a plea this morning, if I have one moment. So put 316, 26. Your Honor, we have Mr. Darice McNab. He's going to be entering a plea, Your Honor, on two cases. First is case number 25 CF 2439. Second case number is 26 CF 0472. You have that, Madam Clerk?
We have it.
Okay. Oh, no. I made a mistake on here, Your Honor. I'm sorry. All right. Sorry about that, Your Honor.
That's all right, sir.
All right, on case number 25 CF 2439, he's going to plead as charged. It'll be an adjudication of guilt. For count one, it'll be adjudication of guilt, 2 years probation, 24 hours community service, substance abuse eval and treatment, standard court costs, $150 public defender fee. Count two is going to be a credit time served. On 26 CF 0472, count one is going to be an adjudication, 2 years probation concurrent, $2.69 restitution to Tom Thumb, no trespass to Tom Thumb, shoplifters awareness course. If I may approach, Your Honor, I have the signed plea form.
Do you have an extra one?
I don't, I will email it over to you.
And, Your Honor, I will, when I have a break, I'm gonna run downstairs and grab a score sheet, but I don't believe there's any objection to the score sheet. It's showing a total score sheet of 21.10.
I've seen the score sheet, Your Honor, there's no objection. If I may approach.
Granted. All right, raise your right hand, please. It's all right. And help him get his hand up, will you, with the papers? Raise your right hand. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you can put your hand down now. Now, you heard what Mr. Cochran said on your behalf, and you signed the written plea form. Is that yes?
Yes, sir.
Okay. How old are you?
37.
How much school do you have?
11 years.
All right. You able to read and understand the plea form?
Yes, sir.
Mr. Cochran, you need to probably approach and sort through this. I think I got either an extra page or I'm confused. That's okay. All right. And is what you read in the form what Mr. Cochran announced to me?
Yes, sir.
All right. Now, do you understand that you're pleading no contest to the announced charges?
Yes, sir.
And by pleading no contest, what I understand you to say is that you believe the state could prove your guilt and you're not going to contest that.
Yes, sir.
And by doing this, do you understand that you're waiving your right to a trial where the state would have to prove your guilt?
Yes, sir.
In this case, you're going to be adjudicated guilty, be on 2 years of probation with 24 hours community service, the evaluation of recommended treatment and the fees and costs. And you can't go back to the Tom Thumb, and you have to take the class.
Okay.
Mr. Cochran answered all your questions about the plea and how it affects you. Has he answered all your questions?
Yes, sir.
You satisfied what he's done for you?
Yes, sir.
Court will find the plea to be freely and voluntarily entered into and accept the plea.
Your Honor, I would also ask that the first year of cost be waived. She will be doing the substance abuse and treatment. She has to pay for himself.
All right. I'll waive the costs of supervision for the first year.
So you don't pay for probation fees for the first year, okay? All right, keep it up. I may keep this one.
I have one moment, Your Honor. Your Honor, I'm going to ask to set this back for 5/11. There is a plea that we are very close on. My client has asked me to speak to the state about something else. Likely bring this to for a plea before May 11.
All right.
Oh, I'm sorry, I didn't announce the case here. Sorry, we have Mr. Robert Orso, Your Honor. I don't have this case number.
It's 24 CF 2476.
Thank you.
All right, so full continuance and you're negotiating, you expect that you'll have a plea before then?
Yes, Your Honor, we're pretty close. My client has asked me to bring some things to the state's attention to see if that affects it at all.
Okay. All right, it'll be continued.
Thank you, Your Honor. Your Honor, we have Ms. Sherry Nicholson.
This is Ms. Sherry Nicholson, 25 CF 1261, as well as 25 CF 2303.
Your Honor, we are in negotiations on this, and in the second case that Ms. Sherry has. I'd ask to set this for the 5/11, with understanding we likely will have a plea before then.
State?
No objection, Your Honor.
All right, continue to 511.
Thank you, Your Honor. Your Honor, I have Ms. Jennifer Nolan, case number 25 CF 2458 and case number 25 CF 1194. Your Honor, I'm asking to set this for the May 11 court date. My client has a third case that has come up, and I'd like to keep them together.
Do you have a case number yet?
I don't have that with me. Your Honor. I believe that case is already set for the May 11 court date.
Your Honor, it is 26 CF 250.
26 CF 250. And what is the status of that case?
That is a brand-new case, Your Honor. We just had arraignment on it.
That is correct, Your Honor. We had felony arraignment on March 12th of 2026, and it was set for 5/11.
All right. And so the state's in agreement to move all the cases to travel together?
Yes, Your Honor.
All right, Madam Clerk, so ordered.
I think they turned it back. You need to talk to them? Yeah, sure. Okay. Yeah.
Judge, while they're pulling, inmates might call someone present in the courtroom.
Yes, sir.
Judge, last name is St. Jean, first name is Kervin. This is 25 CF 2107, and he is present and approaching.
Yes, sir.
And Your Honor, if I may also add a misdemeanor case to today's morning docket.
Yes, just go slow, Madam Clerk, keep up.
Absolutely. It's 2025 CT 1146.
All right.
Excellent. Okay, I'll announce the terms. Thank you, Your Honor. Judge, this morning we have a global plea offer on the table. In 25, I'll announce the terms. We'll be pleading no contest. It is 25 CF 2107, count 1 and count 2. This will be adjudication of guilt, 18 months standard probation, with the $40 per month cost supervision, $515 in court costs, $150 in defense costs, forfeit the firearm, no driving without a valid license as a condition for probation, no consumption of alcohol, no drugs without a valid prescription, random breath testing, random UAs, there's 50 hours of community service, maintain gainful employment, or submit 5 job applications per week. To the misdemeanor case, 25 CT 1146, count 1. That's adjudication of guilt, credit for time served, $100 court costs, and $270 in court costs. If I may approach with a signed plea form and the score sheet, Your Honor.
Granted. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
You can put your hand down. You heard Mr. Koch said on your behalf and signed the written plea form.
Yes, sir.
How old are you?
43.
How much school do you have?
High school diploma.
Are you able to read and understand the form?
Yes, sir.
Did you do that before you signed it?
Yes, sir.
And is what you read here what was just announced to me?
Right. It was fully explained.
You understand by this plea arrangement that you're pleading no contest to the charges? And that says to me that you believe the state could prove your guilt, and you're not going to contest that. Do you understand by doing this also that you're waiving your right to a trial by jury? In this case, you'll be adjudicated guilty and be on 18 months of probation with the fees cost were announced, forfeit the firearm involved, and do you think anyone else would claim an ownership interest in the firearm, or is?
That's a possibility, yes, sir.
There it is, so that's something you should probably discuss right now if you think someone else may claim an interest, and engage the state with that.
If I may,
All of this would be that you disclaim any ownership in the firearm whatsoever. For 60 days, disposition of the firearm be reserved for the lawful owner to present proof to the state attorney adequate for them to agree to ask the sheriff to release it in the event the person is not disqualified for the transfer of the firearm. All right? Is that acceptable to you?
Yes, sir.
All right. Now, also, one of the conditions is you can't drive unless you get a license, no substances without a prescription, and testing to prove that. You got 50 hours community service. You've got to get a job or be seeking a job. And if you want to seek training or education that will lead to full-time employment, then you can speak to probation about that, and I will find that that satisfies your employment conditions as long as the goal is to full-time employment. Then that'll be okay with the court. And then as to the CT case, it's credit for time served. Now, the court notes that there's an outstanding FTA on the CT case. State intend to take no action?
No action, Your Honor.
All right. All right. And the fees and costs in the CT case will be paid during the pendency of the felony probation. Now, with all of that, have all your questions about the plea and how it affects you been answered by Mr. Koch? Are you satisfied with how he's represented you? The court will find the plea to be freely and voluntarily entered into and will accept the plea. If you step this way, please.
Judge, may I call Basil Treleaven?
Yes.
He is approaching 25 CF 1553. We set it today for him to take care of business and pay restitution ahead of time. That's been accomplished. Showed the receipt to Mr. Snell. I believe the state may have an announcement at this time.
That's correct, Your Honor. I'm holding a receipt that shows that Mr. Treleaven has paid the $922.85 to made out to First Bank. It's now Renaissance Bank, and so at this time the state would announce a null pros in the case.
All right. Case is null pros. Thank you now.
Okay, this is yours. Keep the receipt. You're good to go. Thank you, Judge. And Judge Matthew Warner is also on today's docket in 25 CF 2230. We'd set the case over today to see if we could find Mr. Warner because he did not appear at pretrial.
Correct.
I've been given information that he's incarcerated in Alabama on unrelated charges, so I will defer to the court. He is not present in the courtroom today.
State.
In the past, Your Honor, Mr. Warner has kept in contact with Mr. McKinney, and okay, and just ask for a capias.
All right. Issue a capias, Madam Clerk.
Thank you, Judge. There are several other matters in the courtroom that I'm still working on.
All right.
Mr. McKinney?
That's an individual.
Are you good with this? I'm sure we're good.
Your Honor, we have Mr. Ruben McKenna today on case number 25 CF 2316. Your Honor, today my client's going to be entering a plea. In exchange for a plea of no contest, the state has agreed count 1 would be dismissed. Count 2 would be reduced to a lesser included offense of resisting without violence, adjudication of guilt, credit time served, court cost, and public defender fee. If I may approach, I have a signed plea form. I also have the score sheet from the earlier case.
Do I need to fill something out, Mr. McNab's score sheet?
Say again?
Do I need to fill something out?
Put 2 years.
I'll put it
No,
in.
you
Okay,
do.
I'll make sure.
This is McNab's score sheet. All right, and so on Mr. McKinney, this is lesser included misdemeanors only, correct?
Yes, Your Honor.
Count 1's dismissed. Raise your right hand, please. Excuse me. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes.
And put your hand down. You heard what Mr. Cochran said, you signed the written plea form?
Yes.
You understand by this plea arrangement, you're pleading no contest to the lesser included offense, waiving your right to a trial by jury, and you'll be adjudicated guilty since the time served with the fees and costs. And Madam Clerk, those are?
270.
Plus 150, right?
Yes, Your Honor.
How much time do you need to get those paid after your release? A year enough?
Yes.
All your questions been answered about the plea and how it affects you?
Yes.
Satisfied with how you've been represented?
Yes.
The court will find the plea to be freely and voluntarily entered into and will accept the plea.
Thank you, Your Honor.
Is there a statute for the lesser included?
I will need it for you.
843.02.
Good morning, Your Honor.
Good morning.
Chris Garrett on behalf of Tyrell Marshall, 26 CF 120. Your Honor, this was set for plea to continue. We'd request a continuance to pretrial.
Staff have no objection, Your Honor. I think we're going to be resolving this. Just need a little time. And just for the court's awareness and the clerk's awareness, he also has open cases in 25 CF 1982 as well as 26 CF 216, and Mr. Cochran is his counsel in those cases.
Right, on the 192 and 216, and Mr. Garrett is just on the 120, right?
Yes, Your Honor.
Yes, Your Honor.
All right, so full continuance with the belief that you'll resolve it before then.
That's correct.
Yes, Your Honor.
You agree, Mr. Cochran?
I do, Your Honor.
All right. All right, so ordered.
Proceed this week or next week?
Y'all too now. Good day.
And Your Honor, I believe I have one other client on the docket, Logan Lawley, Lollie, 25 CF 1647. This was set for plea to continue. We're requesting a continuance to the next pretrial. However, I very much anticipate resolution at the next pretrial.
State?
No objection or also, but Mr. Garrett, if we can get it in on an earlier date before the pre-trial resolution, we will do
Yes, absolutely.
All right, 511 with the understanding you'll bring it in soon.
All right, sounds good.
All right, thank you, Mr. Garrett. Good
Thank you,
day.
Your Honor. Have a good day.
And once again, Mr. Garrett, thanks for letting Ms. Natali know. As long as you inform folks, don't have any problem with you arriving when you do.
Thank you, Your Honor. I appreciate that. Have a good day.
Good day, sir.
Judge, while they're bringing inmates, may I call one more case?
Yes.
Judge, This is last name Simmons, first name Marcus, 25 CF 1782. Mr. Marcus Simmons.
Yes, sir, I have it.
Judge, he was present this morning. I do have a misdemeanor plea form. The count 1 is going to be a lesser included offense of possession of drug paraphernalia. That's Florida Statute 893.147. We'll be entering no contest plea, withhold of adjudication, 270 court costs, 150 defense costs. If we may get a year to pay, and if I may approach.
State?
That's the agreement. That's Mr. Simmons?
Correct, Marcus Simmons.
Please accepted.
Thank you, Judge. You should have signed it. Sure. While he's looking that up. Absolutely.
Well, it sounds like a good time for a comfort break, because I need one anyway, and another cup of coffee, so we'll take.
All right,
Just
please.
let bailiff know when you're ready, I'll be back, okay?
Yes, Judge.
All right, thank you.
sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire, take one. Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa!
Not cool, bro. I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire, take 1. Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa!
Not cool, bro. I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
There's also another case number that should be with that VOP, if I may provide it.
Yes, sir.
It's 2019 CF 431.
All right, you on board, Madam Clerk?
Yes, Your Honor.
Okay, all right. Go ahead, Mr. Koch.
Judge, on that 2019 case, it's one of those VOPs, I don't know if it shows, well, has he been served yet? I just want to make sure that he gets properly served so it's not just hanging out there.
I see an order revoking bond and commanding arrest. That looks like that was from first appearance on 1/7. Then I see the subsequent report of the violation. So I think he's been arrested on the VOP, which was a PC VOP by the judge at first appearance. So I don't think there is an outstanding warrant. I don't see that one's been requested.
Okay. Thank you for verifying that, Your Honor. And of course, with that 2019.
So I guess because of that, I don't think it's ever been set for arraignment.
That is correct, Your Honor. And if we can also be officially appointed to that case, the PD's office,
The
Your Honor.
PD is appointed to 2019 CF 431.
Okay, thank you, Judge.
Enter a denial.
Enter in denial on that case, Your Honor.
All right.
And then I also have an update reviewing that plea form originally was back in August 4th of 2021. That's that 19 and the 21 case.
Right.
Per that agreement, there's a 5-year suspended sentence on that case, Judge. And here we are in a violation of probation. The current offer is the 5-year suspended sentence. Because I remember last time in court we were trying to go forward with a resolution. Unfortunately, we cannot accept that today because of that suspended sentence. I am requesting if we could put this on that April 23rd, I believe it's the 23rd VOP docket with subpoenas. This will give enough time to go out to the jail and just start gearing up for that potential hearing.
All right, so 423 with subs.
With
We already have 11 set for that afternoon.
Already have 11 set in the afternoon on 423.
Could we get the next court date after?
Now, what date is that, Madam Clerk?
May 14th.
514 at 2.
Correct. That's the current offer. So our next court date's 5/14 with subpoenas. The current offer is 5 years. That suspended sentence. Of course, if there's a resolution, we can bring it in sooner, but as of right now, it's 5 years. That's the current offer.
All right, and so we're going to move all of these cases to 514 because the state wishes to try the VOP first.
Yes, that's correct, Your Honor.
All right.
Hopefully that will resolve the new law as well.
All right, 514 with subs.
Thank you, Judge.
Thank you.
Your attorney? Let's go a little bit. Jacob Roberson, Your Honor, in 25 CF 503, 25 CF 1435, 25 CF 1638. Those are all the violations of probation, and I want to give that the new law case, which is also in front of this court, 26 CF 279, Your Honor.
Yes, sir.
And if I may approach with Mr. Snell and probation. On our end, 511?
Yes, for status only.
Thank you, Judge. And if I may call one case, Your Honor, with Mr. Gomez?
Yes.
Judge, this is Mr. William, last name Pearson, 25 CF 1781.
Your Honor, at this time, the state would announce a no cross in 25 CF 1781. We've been unable to contact the victim. This is a case from 2013, or the facts are from 2013.
Right.
So at this time, we would no cross.
Case is no cross.
This case? Yep. Is a plea. Count one's going to go from dealing with property by organized trafficking to dealing with property. Other than that, it's on the paper because I didn't know we're talking about probation.
I'll set it up for lenient offer.
Yeah, he knows we've been looking at it. Judge, this is an interpreter case. This is Mr. Silvancello Perez.
Do you swear to interpret these proceedings truthfully, adding nothing and subtracting nothing? Right.
May I have just a moment with Mr. Tello Perez?
Yes, and what's that case number?
He has three case numbers, 23 CF 489, 26 CF 112, and 26 CF 192.
Thank you.
Mr. Tello Perez is before the court in three different case numbers as stated. The state has made an offer to Mr. Tello Perez that is credit for time served. Mr. Tello Perez wishes to accept that offer. However, with the language barrier, I would request that we add this on Thursday's docket in the morning if the court will allow, so that I could review the plea agreement with an interpreter in full. Because there will be immigration consequences based on this plea agreement.
All right.
So that would be Thursday morning?
Thursday
Change of plea?
morning. Will that give you adequate time?
If I double time. Yes, Judge. At minimum, I will have the opportunity to put the plea agreement together in writing and review it in full with Mr. Perez.
And you'll have the assistance of the interpreter in doing that? An interpreter to do that?
Yes, Judge.
Okay.
I'll coordinate with my office to see if I can get an interpreter tomorrow or Wednesday. I believe that that is possible.
Okay.
At minimum, that's something that I can review at the courthouse on Thursday morning with more of a chance to speak to Mr. Tello Perez. But the intention is to review the agreement with him at the Okaloosa County Jail to answer all of his questions.
All right, change of plea on 3/19 at 9 o'clock.
Thank you, Judge.
Thank you.
Thursday is going to be 19th. But I'm going to try to come see you tomorrow or Wednesday. Okay? Okay. Thank you.
He just told me the top page is going down, going property. That's the state possession number, that's what it's going to be level 4. Here's the score sheet. The offer? Yeah, this is the score sheet. This is going to be reduced. It's my understanding, or is this going to be, this is what it's going to be? Correct. Okay, so I missed different section of it, but this is what it's going to be.
Yeah, it's basically, it's a lesser.
The F2, okay.
Yeah.
What is this offer, so I can type in the score sheet for Jason? That's what I'm asking for. And I don't know anything about this case, so. Okay. Is there, of course, no return to this location?
Okay, yeah.
Is there any restitution? No, that's fine. Do you have that number for me? Yep, I'm gonna let you write it here, because I'm just gonna back up. You put the ABs on there for me. Okay. Righteous.
Judge, may I call Mr. Christopher Williamson out of the courtroom?
Yes, sir.
Mr. Williamson is approaching in 25 CF 1895.
1895.
Correct.
All right.
And we have been going back and forth with the state on offers, counter offers in this case. I believe that we are close to an agreement. Mr. Williamson wants to come in and talk to me at the office one more time. It was set plea or continue. So I would ask for the continuance until May 11th with the intention that after he comes in and meets with me and reviews the plea terms, then we could likely add this back on for an early plea.
State.
No objection.
All right, so ordered. Stay in touch with Mr. McKinney and be back in court on the 11th if he doesn't tell you sooner.
Thank you. Make an appointment. Judge, may we call Jeremiah Wright?
Yes.
Mr. Jeremiah Wright is present before the court. Today's 3/16/26. This is case number 24CF2061. We have reached an agreement at this point for Mr. Wright. This is a two-count information that's currently charged. Count one is going to be a plea to a lesser included offense of aggravated battery with great bodily harm. That is a second-degree felony. That, Madam Clerk, that is 784045 sub 1 sub A1. Count two would be a plea as charged to the third-degree felony. The agreement with the state for this agreement is a withhold adjudication. 5 years of state probation with special conditions of no contact with Joyce Palco Leuen, no contact with David Alex Brown. He must complete an anger management course. Probation, I have written the Bridgeway program or equivalent.
Yeah, Bridgeway no longer does anger management, so it'll be Patterson's.
So it would be Pattison?
Yeah.
Okay. Is it, if we say equivalent program, is that fine?
It should be okay.
Okay. No drugs without prescription, random urinalysis, no alcohol, random testing, maintain gainful employment. Restitution is going to be reserved related to David Alex Brown. Standard court costs are $867. There's a $150 cost of defense. We are going to request that the court consider waiving the cost of supervision. He is currently trying to get his license back and is paying through some child support issues that is eating up a lot of his funds. And taking care of several children. May I approach with the plea agreement?
Granted.
I have reviewed this with Mr. Snell, and based on the change in count one, that is a level 7 offense. So we stipulate that this is going to be a downward departure, but the state would have to prepare and submit a score sheet. May I approach?
Granted.
Do you have an extra copy?
I do.
All right, raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, Your Honor.
Okay, and you can put your hand down. You heard what Mr. McKinney said, and you signed the written plea form.
I did.
How old are you?
47.
How much education do you have?
GED.
You able to read and understand the plea form?
I do.
Did you do that before you signed it?
I did.
And it's what you read in the form, what Mr. McKinney just told me.
Yes, sir, it is.
Do you understand by this plea form that you're pleading no contest to the announced charges?
Yes.
And that says to me you believe the state could prove your guilt as to those charges and you're not going to contest that?
Yes.
Do you understand by making this plea you're waiving your right to that trial by jury where the state would have to prove your guilt?
Yes, I do.
Excuse me. In this case, adjudication will be withheld. You're going to be on 5 years of probation, no contact with the named persons. Have to take the class that was discussed, no substances without a prescription. You must get a job or be searching for a job, and you will have to pay the restitution. The amount will be reserved. Is that what you understood?
Yes, Your Honor.
All right. And has Mr. McKinney answered all your questions about the plea and how it affects you?
Yes, he has.
And you satisfied what he's done for you?
I am.
Court will find the plea to be freely and voluntarily entered into and accept the plea.
So withhold?
With a withhold.
Just making sure. As to the cost of supervision?
Say it.
Does the court have a position as to the cost of supervision?
Where's the cost of supervision?
Thank you, Judge. Judge, I have 2 more plea agreements to write for inmates that I have already discussed with them, but I still need to draft real quick.
Okay. Well, I'll just step off the bench and let y'all do that. I know Mr. Nopes is working his cases too, and so y'all just have the bailiff text me when you're ready and we'll get it.
Thank you, Judge.
All right. Go back.
I can do 3 right now.
You can do 3 right now?
Yep.
You ready? All right, well, let's do 3 right now, and then we'll do that. Then I'll go push some pixels.
All right, Judge, I think the first one I've got is Trevor Brown.
In that case number, Mr. Nopes?
I'm sorry, Judge, 25 CF 758.
All right. All right, because Mr. Griffith represents him on the other case, right?
That's correct, Your Honor.
And that one was continued, and you brought yours over for POC today, correct?
That's correct, Your Honor. We're going to go ahead and resolve this case.
All right, very good.
I'm doing these 3, not 10. None of yours right now. Yeah, I think you're fine, yep. All right, Mr. Brown. Sign right there. Okay. May I approach, Your Honor?
Granted. Go ahead, Mr. Nopes.
Judge, we're entering a plea as charged with the understanding he'll be adjudicated guilty and receive sentenced to 11 months and 29 days in the county jail, and giving credit for all time served, $515 in court cost, and $150 in court-appointed legal assistance fee.
All right. Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you can put your hand down. You heard what Mr. Nopes said. You signed the written plea form.
Yes, ma'am.
How old are you?
I'm 19.
How much school do you have?
School, I'm in the 11th grade.
All right. You able to read and understand the plea form?
Yes, sir.
Did you do that before you signed it?
Yes, sir.
And it's what you read in the form, what Mr. Nopes just announced to me.
Yes, sir.
Do you understand by this plea agreement that you're pleading no contest to the announced charge?
Yes, sir.
That tells me you believe the state could prove your guilt and you're not going to contest it.
Yes, sir.
You understand by doing this, you're waiving your right to that trial where the state would have to prove your guilt.
Yes, sir.
All right, in this case, you'll be adjudicated guilty, sentenced to the 1129, credit for all time served, and you'll have the fees and costs. I'll give you a year to pay those after you're released from jail, okay?
Yes, sir. Thank you.
Mr. Nopes answered all your questions about the plea and how it affects you.
Yes, sir.
Satisfied with what he's done for you?
Thank you.
Are you satisfied with what he's done for you?
Yes, sir.
All right, our court will find the plea to be freely and voluntarily entered into, and will accept the plea. Thank you.
Good luck. Judge, I then have Fernando Medina, 24 CF 2462. Yes. Oh, sorry. Judge, if I may approach.
I sign. Yes.
Granted.
Judge, he is charged with an 8-count information, and so he's pleading as charged. The understanding with the state is that he's pleading no contest and will be adjudicated guilty and sentenced to 48 months in the Department of Corrections with credit for all time served. I actually wrote 615, but I think it'd be 515 in court cost because it's not drug-related. 5-year sex offender, it's followed by 5-year sex offender probation, and GPS will be at $1 a day.
Yes, Your Honor, and sex offender designation. I will submit an order for sex offender.
Sure.
All right.
I'm still 100%. Okay.
All right. All right, sir, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, Your Honor.
All right, and you put your hand down. You heard what Mr. Nope said, and you signed the written plea form.
Yes, sir.
How old are you?
32.
How much education do you have?
High school diploma and trade certificate.
All right. Are you able to read and understand the plea form?
Yes, Your Honor.
Did you do that before you signed it?
Yes, Your Honor.
And it's what you read in the plea form, what Mr. Nope's just announced to me.
Yes, Your Honor.
Do you understand by this plea arrangement that you're pleading no contest to the charges?
Yes, Your Honor.
That tells me you believe the state has the evidence necessary to convince a jury of your guilt beyond a reasonable doubt, and you're not going to contest that.
Yes, Your Honor.
Do you understand by making this plea, you're waiving your right to that trial by jury where the state would have to prove your guilt beyond a reasonable doubt?
Yes, Your Honor.
In this case, you'll be adjudicated guilty, and you'll be sentenced to 48 months in the Department of Corrections, credit for all time served, followed by 5 years of sex offender probation with all those conditions and the GPS at $1 a day. Now, to be clear, you understand the sex offender probation, the sex offender designation will affect where you can live, where you can work, who you can be around, and a lot of other circumstances. Do you understand that?
Yes, Your Honor.
And anything that you violate there would not only be a violation of your probation, but also could be a separate criminal offense. Do you understand?
Yes, Your Honor.
Okay. Has Mr. Nopes answered all your questions about the plea and how it affects you?
Yes, Your Honor.
And are you satisfied with how he's represented you?
Yes, I am satisfied, Your Honor.
The court will find the plea to be freely and voluntarily entered into and will accept the plea.
Thank you.
Concurrent?
I'm sorry?
Well, that's a good point, because, well, please approach.
In 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
The Department of Corrections on count 1, followed by the 5 years of probation concurrent on counts 2 through 8. Okay? All right, thank you very much.
Thank you, Madam Clerk.
Fire with fire.
Judge, the next case I've got is Devin Moore. And Judge, I'm going to slowly read these case numbers to make sure the clerk's got the same things I'm thinking that I've got in the way of the violations of probation. The new case is 24 CF 327, and then the BOPs start with 15 CF 1708 C, 15 CF 1709 C, 15 CF 711 C.
1711, make sure it's 1711.
I'm sorry?
I just want to make sure it's 1711, not 711.
Oh, I'm sorry. Yes, 15 CF 1711, and then 1712, 1713, 1714, and then it goes to 15 CF 2492, 15 CF 2493, 2015 CF 2774, and 15 CF 2776. Is there anything on the docket that I didn't enunciate or mention? Sorry about that.
That's what we have, Mr. Noakes.
I'm sorry?
That's what we have.
Okay, good. If I may approach, Your Honor.
Granted.
So, Judge, in all those case numbers, we are pleading to 24 CF 327F. The state, we're pleading to count 2, and the state's dismissing count 1 and count 3. And then he's admitting all the BOPs that I've enunciated, the case numbers. Judge, the agreement with the state is that he'll be adjudicated guilty on all case numbers and counts. He'll be sentenced to 20 years Department of Corrections as a minimum mandatory with a $100,000 fine. On the BOP, the defendant is adjudicated guilty and sentenced basically to credit for all time served. The state and the defense stipulate and agree that the defendant is specifically preserving his right to appeal the court's decision on the motion to suppress, and the state is stipulating that the court's decision on said motion was in fact dispositive. And then there's a $1,250 court-appointed legal assistance fee, and I guess $615 on 24 CF 327, count 2, court cost of $615.
No, it would be on count 615 on count 2 or the 1147? Okay. Right. Plus the surcharge. And then $100 cost of prosecution on each of the VOPs, right?
Yes, sir.
Right.
This is, I calculated for 4 years.
All right, raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury? Okay. And you put your hand down. You heard what Mr. Noakes said, and you signed the written plea form.
Yes, sir.
All right. How old are you?
I'm 27, sir.
How much school do you have?
I got my GED.
Are you able to read and understand the plea form?
Yes, sir.
Did you do that before you signed it?
Yes, sir. Correct.
And is what you read in the plea form what Mr. Noakes just announced to me?
Yes, sir.
Do you understand by this? Now, you got two different things going on. You got your VOPs and your new charges. They're different, but we're taking care of them in the same plea agreement. Do you understand that?
Yes, sir.
As to your VOPs, do you understand by this plea arrangement that you're admitting violations?
Yes, sir.
And by doing that, what I understand you to say is you agree that you violated your probation the way the affidavit and report filed by your officer says you did.
Yes, sir.
Do you understand by making this plea, you're waiving your right to a trial, to a hearing where the state would have to prove your violation?
Yes, sir.
Now, as to your new charge, do you understand you're pleading no contest?
Yes, sir.
All right. And by pleading no contest, and we're going to get to the issue about your reservation on the issue of the motion, so I'll get to that in just a second. But by pleading no contest, what I understand you to say is that you believe the state has the evidence necessary to prove your guilt to the jury beyond a reasonable doubt, and you're not going to contest that.
Yes, sir.
And do you understand by making this plea that you're waiving your right to that trial by jury where the state would have to prove your guilt beyond a reasonable doubt?
Yes, sir.
Now, those questions are presuming that the court was right in suppressing, in denying your motion. So I understand you're reserving your right to appeal that. So I want to make clear your statements about that have to do with the court being correct in the ruling, and you're reserving your right to appeal that.
Yes, sir.
Okay, I make that clear, and the state believes that's dispositive, correct?
That's correct, Your Honor.
Right. So I don't want to be any confusion about that.
Thank you.
Now, with that said, and you'll have the announced fees, cost, you'll be adjudicated guilty, and count 1 will be no prost, and count 3 will be no prost. And on the VOPs, you're adjudicated guilty if not previously, and since time served, you'll have the $100 cost of prosecution in each one of those cases, plus the $100 state-provided legal assistance. Then on the principal charge in 24 CF 327, you'll be sentenced to 20 years as a minimum mandatory, $100,000 fine, plus the clerk's surcharge, which is $2,500, the clerk's surcharge? 5,000, right?
5%,
Of surcharge. And then the fines that were announced. Is that what you understood the sentence to be?
Yes, sir. I just have a question about the $100,000 fine. Like, I just don't really understand how that's gonna go about.
Well, you can, if it's not paid, then the clerk will take appropriate action to refer it to collections, and there may be consequences for other situations. I can't answer what those might be. That would be something Mr. Nopes could explain to you. Ordinarily, what happens on these situations is we give you a reasonable period of time to pay it. If it's not paid, then the clerk turns it into a judgment, and then it's sent off for collections. That ordinarily is what's happening.
And just so that, I want to help him understand, you can't be sentenced to any more jail time, but they could, they could charge fees on it and contact you about trying to set up a payment plan, and when collection gets involved, there's going to be fees and costs that they're going to add to it, but they will try to set up something to where you would make payments, I think. So, but you're not facing any more jail time if it's not paid.
Was that your question, really?
I mean, I understand. Thank you.
Okay. All right. All right, with that, have your questions been answered about the plea and how it affects you?
Yes, sir.
And are you satisfied with how Mr. Nopes has represented you?
Yes, sir.
The court will find the pleas to be freely and voluntarily entered into and will accept the pleas. Yeah, probation is revoked and terminated. Thank you, Madam Clerk.
Thank you. Yep. Judge, I don't know that I see Holly Martin present. So Judge, she had 2 separate case numbers, 25 CF 1019 and 25 CF 1029. Judge, she was present here the other day, so I'm really kind of surprised. Maybe I could step out and try to call her if I've got a phone number.
Okay.
And then I've got, well, let me just pass the rest of these until you come back. Take a little break.
Well, I think Mr. McKinney, you ready with some of yours?
I'm still typing, Judge.
Okay. All right. All right, well, just let me know. Let's move the cases. Just let me know when you're ready.
Thank you.
All rise, please.
PF 1262. Thank you. Actually, I'm going to have you sign right there for me. And today is 3/16 of 26. Excellent. Now I'm going to announce these terms. Any questions, you can stop and ask me. If not, we'll just follow along. Thank you, Judge, for that little additional time there for signatures. Thomas Koch covering for Mr. McKinney. This is Mr. Wise. We're going to be entering a no contest plea this afternoon. I first want to notate count 1 is going to be the lesser included offense of dealing in stolen property. That's Florida Statute 812.019, subsection 1, which is a second-degree felony. Counts 2 through 9 will be as charged. So count 1, terms of the plea. This will be a withhold of adjudication, 10 years of standard probation. There's $40 per month cost supervision, Your Honor, and I am going to ask if we can waive that per month cost because there's a heavy restitution amount in this plea agreement. Moving forward, we have $515 in court costs, $150 in defense costs, maintain gainful employment or submit 5 job applications per week, no drugs without a valid prescription, no consumption of alcohol, random breath test, random urinalysis, no return to Cache America Pond, located at 20 Eglin Parkway Southeast, Fort Walton Beach, Florida, 32548. No contact with the alleged victim, Mr. Joseph Rupert. And we have restitution in the amount of $7,500 to Joseph Rupert. This will be a minimum monthly payment of $160, and the monthly payments to start in May of this year, 2026. Counts 2, 3, 4, 5, 6, 7, 8, 9 will be a withhold of adjudication, 5 years of standard probation. All counts to run concurrent. Auto terminate probation at 36 months if all conditions and costs are satisfied and there are no violations. And I do have restitution payable to Joseph Rupert on the bottom of the plea form with his address. If I may approach with the signed plea form and score sheet.
Granted. The state's agreement?
Yes, sir, that's the state's agreement.
Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir, I do.
All right.
Just for clarification, if there's still outstanding restitution owed after the 5 years on the other counts, that outstanding amount is still owed and everything still carries on with the count 1.
Okay, so what you're saying is the completion of all the terms and conditions for all the counts would be within the full 10-year period?
Yes, sir, that's correct.
Okay, all right. How old are you?
I'm 40.
And how much education do you have?
I have some college.
You able to read and understand the plea form?
Yes, sir.
Did you do that before you signed it?
Yes, sir.
And it's what you read in the plea form, what Mr. Koch just announced to me.
Yes, sir.
Do you understand by this plea agreement that you're pleading no contest to the announced charges?
Yes, sir.
And that tells me that you believe the state has the evidence necessary to convince the jury of your guilt and you're not going to contest that.
That's correct. Yes, sir.
And do you understand that by making this plea, you're waiving your right to that trial by jury where the state would have to prove your guilt?
Yes, sir.
All right. And adjudication will be withheld. You're going to be on 10 years of probation on count 1 and 5 years of probation on the other counts. And you'll have the fees and costs, the no substances without a prescription, testing to confirm that. You can't go back to the named places, and no contact with the named person, and the restitution provided with a minimum payment made. Is that what you understood?
Yes, sir.
And you can terminate you can terminate your probation if all of the conditions are satisfied within 36 months and you've had no violations.
Yes, sir.
And as you heard, you've got the full 10 years to complete everything if you're not able to get it done before then. Mr. Koch answered all your questions about the plea and how it affects you?
Yes, sir.
You satisfied with how he's represented you?
Yes, sir.
Court will find the plea to be freely and voluntarily entered into, will accept the plea.
And Your Honor, on the waiving the cost of supervision per month for the restitution?
Granted.
Thank you, Your Honor. It's a withhold, do you need fingerprints? Thank you. Probation, you're welcome.
From last week to today. All right, wise is good. Okay. Have anything else?
No, everything else is good.
Rock off.
So, right there, there's the 16.
It's like that next week.
Your Honor, may I approach?
Granted.
This is Jared Smith, 25 CF 180F, which is the new law violation, and 25 CF 2536F, which is the violation of probation. The court, previously, we had a BOP hearing, and the court found that he had in fact violated his probation, but we've got a resolution that takes care of all of it.
All right.
So Judge, well, that ain't what I wanted. So Judge, in 25 CF 180, that's the new law violation. The state's going to dismiss count 1, which is the felony, and we're going to enter no contest to the 2 misdemeanors. Then the 24 CF 2536, which is the violation of probation, instead of going to sentence, we've agreed on a sentence on that case. Judge, he basically would be adjudicated guilty on everything. On the felony VOP, 24 CF 2536, he would be sentenced to 16.875 months, Department of Corrections, with credit for all time served. On the felony new law violation case number, those misdemeanors, he'd have $270 in court costs, and then he'd catch a $100 VOP fee for the violation of probation case. There'd be $250 in court-appointed legal assistance fee, and adjudicated on count 2 and 3 of the 25 CF 180, and he would be sentenced to time served because they're misdemeanors.
All right. Is that the state's agreement?
That is, Your Honor.
All right, raise your right hand for me, please. Do you swear affirm to testify truthfully in this matter under penalties of perjury?
Yes, Your Honor.
Okay, you put your hand down. You heard what Mr. Nope said and you signed the written plea form?
Yes, sir.
All right, how old are you?
I am 39.
How much school do you have?
Some college.
Are you able to read and understand the plea form?
Yes, Your Honor.
Did you do that before you signed it?
We went over it. I didn't actually read it.
Would
If I
you
could-
like some time to do that right now?
Yeah, can I take a look at it and make sure I
Yes, sir.
understand it completely?
Yes, sir. Absolutely. And I'll turn this obnoxious noise on, so if you've got questions, Mr. Nopes can answer. All right. Now, have you had an opportunity to completely read and understand the plea agreement?
Yes, Your Honor.
And is what's in the plea agreement what Mr. Nopes just announced to me?
Yes, exactly.
All right. So, and previously, we had a hearing on the VOP where the court determined your violation. However, you and the state have reached an agreement regarding that sentence, and this takes care of that in addition to your new charges, right?
Yes, Your Honor.
All right. So, as to new charges, you understand that you're pleading no contest to the announced charge, waiving your right to a trial by jury. Is that right?
Yes, Your Honor.
And then there's an agreement regarding your sentence on all of them. You'll be adjudicated guilty. And on your new charge, it's credit for time served with the fees and costs. And on your VOPs, it's 16.875 months Department of Corrections credit for all time served with the fees and costs were announced. Is that what you understood?
Yes.
All right. Is 2 years to pay your fees and costs enough time after you get out?
Yes, Your Honor.
All right. Mr. Nopes answered all your questions about the plea and how it affects you?
Yes, he did.
Are you satisfied with what he's done for you?
Yes, very much so.
The court will find the plea to be freely and voluntarily entered into and will accept the plea. Probation revoked and terminated. Thank you.
Thank you,
Step
Judge.
over this way.
Judge, I did check on Holly Martin, 25 CF 1019 and 1029. Judge, I did not have a phone number on her. I do have an email address that I'll email her when I get back to the office, but I don't have an address. Again, I was really surprised that she's not here today because she's been here a number of different times. Is there any chance that the court would agree to continue it?
State?
Because of Ms. Martin's presence in court, and her her consistent communication with Mr. Nopes, with the exception of today, we'll go ahead and continue. Can we set it for a status to make sure that she's present on 419 or
416?
416?
That should be fine, Judge.
That's our miscellaneous day.
That's fine, Judge.
Yes, 416 for status. I think that you might have a possible disposition anyway, right?
That's correct.
Yes,
So
yes,
the
sir.
sooner the better.
And then, so do you want to put it on the pretrial docket for May?
Yeah, we'll put it there, that way I don't have to forget to deal with case status.
Okay. Judge, the next case I've got is Medici. Judge, the state.
What's that case number?
Well, that's interesting, Judge, because actually it's not on the docket, although I had put down that it would be on the docket today, but the case numbers are 24 CF 2794 and 2799. The state was trying to give an offer.
And also 688, right?
Oh, well.
25
Yes,
CF
yes.
688.
Yes, the file behind it. So Judge, he's working on an offer, but we might just be best to bring it back for another day.
All right, state?
That'll be fine. I think this is one we'll work out. I didn't have it on the docket, so.
It wasn't on the docket. It was just on my client sheet said that when I was here on the 9th, that it was left set for 3:16 at 9 a.m.
Well,
So,
that's what my notes show as well.
but it didn't make it. It didn't make it to the
It was
docket.
set for plea or continue today,
Yes, sir.
but it didn't make the docket for whatever reason.
Right.
But that's okay, we'll continue it. Stay in touch with Mr. Nopes and be back in court on the 11th unless he tells you sooner, okay?
What day is the pretrial?
It's going to be 5/11.
5/11. Very good. All right, and then Judge, the last case is Cody Owens, 25 CF 221. Cody Owens. Judge, the state and I have agreed to continue this.
All right, is there, I think the last time we talked about this, there was a minimum mandatory offer. Is that still where we are?
That's still where we are. Judge, I extended the counteroffer, but it's not something that the state's able to do, so I've got to meet with her and decide if we want to do depositions, basically.
All right, we'll continue to 5/11 then.
Okay. Judge, I think that's all I've got. I'm no longer representing.
Who represents Mr. Leuen?
Charles Williams, Your Honor. I believe that's all I've got.
Madam Clerk, is that all for Mr. Nopes?
We're still showing as Mr. Nopes representing Mr. Brian Lanu.
They're still showing you as representing Mr. Lanu. There's an order that was signed that my office received.
It looks like we did get a notice of appearance from Mr. Williams.
So, Judge, on Mr. Lanu's cases, Mr. Williams filed a notice of appearance on
Friday.
Right.
Yeah.
And the order come out, I think, that same day.
All right. Just continue it, State?
No objection.
All right, the matter will be continued, 5/11.
Yeah, I remember the court to go, that was
Right, Mr. Lanu was present, yes.
Judge, this is Mr. Anthony Weaver. He's set on today's docket 25 CF 823. He didn't make it on the pretrial transport list.
Yes, sir.
So we are going to have a mental health court staffing on Wednesday. Part of the discussion with the court is making sure that we have housing for Mr. Weaver. We've secured that. So this may fall off the docket after mental health court on Wednesday. If we just want to set a control date afterwards to make sure.
We'll just set it for 5/11 and just be sure that you communicate effectively with Madam Clerk if it rolls off.
Will do.
All right. Thank you now, Mr. Weaver.
Do you have any questions for me? I try it. I beat them up all weekend on it too. They still don't know. You sure? Okay. I need to sign it and take it here. Judge, this is Latana Williams before the court in 25 CF 2381. Today is 3/16/26. Yes, I don't have a copy I can hand you right here, though. Yeah. As soon as you get out, do you have any written address? Judge, the agreement that's been reached in Ms. Williams' case in 25 CF 2381 is for a plea as charged. The agreement calls for a 12.1-month Department of Corrections sentence with credit for time served. And because of her incarceration status out of Santa Rosa County, the state has agreed, stipulated to credit going back to January 20th of 2025. That would be a net effect of a credit for time served sentence, and the state stipulates that that sentence has been served per this agreement. There is the standard court cost of $515, a $150 cost of defense. There's restitution in the amount of $500 to Lisa Secrest, spelled Secrest, of 251 Wakissa, Wakissa, CV, that's Destin, Florida, 32541. That amount would be sent to civil lien. We would ask for the court costs to go ahead and be sent as well. What you got? If you were on probation, that's how much it costs per month, but you're not on probation. You good? Okay. Do you have a score sheet? Or do I need to print one? May I approach with the plea agreement?
Granted.
As part of entering this plea agreement, if I can talk for a second, the defense had filed a motion to dismiss in this case. I believe it was not filed until this morning. We would be withdrawing that motion to dismiss in exchange for entering the plea in this agreement.
All right. Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right, and you can put your hand down. You heard what Mr. McKinney said, and you signed the written plea form?
Yes, sir.
All right. How old are you?
I'm 37.
And how much education do you have?
High school diploma.
You able to read and understand the plea form?
Yes, sir.
And did you do that before you signed it?
Yes, sir.
And it's what you read in the plea form, what Mr. McKinney just announced to me.
Yes, sir.
And do you understand by this plea that you're pleading no contest to the announced charges?
Yes, sir.
That tells me you think the state could prove your guilt and you're not going to contest that.
Yes, sir.
And by doing this, do you understand that you're waiving your right to a trial by jury where the state would have to prove your guilt?
Yes, sir.
In this case, you'll be adjudicated guilty and sentenced to 12.1 months Department of Corrections, credit for all time served, and that includes the time that you've served since 1/20 of 25, and the state stipulates that you've completed your sentence, and that therefore this is a sentence to credit for time served.
Yes, sir.
You'll have the restitution that was announced, which will be sent to a civil lien, as well as the costs, which will be sent to a lien as well. Mr. McKinney answered all your questions about the plea and how it affects you.
Yes, sir.
And are you satisfied with how he's represented you?
Yes, sir.
The court will find the plea to be freely and voluntarily entered into and will accept the plea.
Thank you, Judge.
Thank you.
I'll make sure a copy is dropped off.
Yes.
Did you do that before you signed it?
Yes, sir.
And it's what you read in the plea form, what Mr. McKinney just announced to me.
Yes, sir.
Do you understand by this plea arrangement that you're pleading no contest to the charges in question?
Yes, sir.
And that tells me you believe the state could prove your guilt and you're not going to contest it.
Yes, sir.
In addition, do you understand by making this plea, you're waiving your right to a trial by jury where the state would have to prove your guilt?
Yes, sir.
In this case, you'll be adjudicated guilty, sentenced to 24 months, Department of Corrections, credit for all time served, concurrent and coterminous with the announced cases in Santa Rosa County. And the state stipulates that you serve that sentence, and this is essentially a credit for time served sentence.
Yes, sir.
And you'll have the restitution that was described, which will be sent to a civil lien together with your costs that were announced. Is that what you understood?
Yes, sir.
Has Mr. McKinney answered all your questions about the plea and how it affects you?
Yes.
And are you satisfied with how he's represented you?
Yes, sir.
Court will find the plea to be freely and voluntarily entered into and will accept the plea.
Thank you.
Thank you, Judge.
Thank you.
Yes.
I have one on the docket, wasn't transported for some reason this morning. Mr. Riskish Mosley, 23 CF 2386.
Sir,
Your
we got
Honor.
it for POC today, all right?
Yes, Your Honor. Well, I'd ask to send him for 511. The plea is the plea. It's not going to change. If he's not ready to accept it, I guess we'll move for trial next period.
State?
That's correct, Your Honor.
Okay, 511.
Thank you, Your Honor. I believe that concludes my business, Madam Clerk.
That's correct.
Thank you, Your Honor.
All right, we got anything else, Madam Clerk?
No, Your Honor.
All right, looks like, now let's quickly review our trial schedule, okay?
Should be relatively
No.
minimal.
It has, I think, been pared down substantially. All right, so I've got Mr. Anderson, of course, with Mr. Little, I believe it is. And right now, that's set for 26 and 27.
That's right, yeah.
Then I've got Emmanuel Colley, and that's, I think we were setting that directly to jury review, I believe. And then we've got Guy Nelson, who also was set directly to jury review. And that's what we have, those three. Do your records agree?
My record, yes. On Nelson, yeah.
Your Honor, may I step out real quick and call Mr. Little just to make sure in regards to Colley that it's set straight to your review?
Yes.
I just want to make sure.
Is that his case?
Yeah, I think so. I think it's, no, I think it's Rob's
I
case.
think it's Mr. Little's. I'm going to double check before I call him.
That's him and Mr. Early.
That's what I thought.
Mr. Early was on Zoom.
Is Mr. Early on Zoom? He wasn't earlier.
I think they put him straight to jury trial review. But
Okay.
I'll let Mr. Gomez confirm.
Looking at the notes from 311, it was sent straight to jury review.
Yeah, that's what my notes say too. And then we just directed them 48 hours before jury review to file the motions in limine. It really looks like Nelson may be a plea, correct?
That is
Mr.
correct,
Damer?
Your Honor. It may be,
Okay, so that leaves us with Anderson and Colley.
yes.
Okay, all right, so Anderson, Colley, and Nelson.
Yes, Your Honor.
Okay, well, we'll see y'all, well, Thursday, I was gonna say Friday, but we'll see you Friday on the trial docket.